This is The Law Matters. Of course it does. This program has been created to educate, inform, and help you to decide how to protect yourself, your family, and your business regarding law matters. Hi, I'm Debbie Moraes, your host and moderator. As we've told you, we provide information and resources that may help you better understand the law, perhaps manage some issues yourself. But if you do decide to seek outside legal counsel, our goal is to help you be better prepared, and of course, so will the counsel you select. Our goal, as always, is to save you time, money, and we want you to achieve the best possible results. We want to welcome, again, as always, Attorney David Bazar from the Bazar & Associates Law Firm in East Providence, who continues to offer his legal information, his expertise, and his anecdotes on the various topics that we present. Today, the court system and its judges. So as the supreme law of the land, the U.S. Constitution creates federal system of government in which the power is shared between the federal government and the state governments. Each has its own court system. We're going to explore that today. So what are the differences between the structure, the judicial selection, the different cases that they hear? And what about those local courts? Lately, there's been an awful lot of contentious challenge, serious clashes between and among these systems, and the Supreme Court, known as the highest court in the land, it's been having to hear some very challenging cases. We'll discuss those relative to the executive branch, better known as the Trump administration. So today, let's see if we can have a better understanding of the process as well as the people who are involved with it. So, David, I guess for years, forever, there's been debates about how judges are selected and who covers what. So give us a little primer from the federal side. Start with the federal side. Okay. What does that break down as?
So as you know, the Constitution has created 3 branches of government. And in Article 3, it creates the judiciary, and they each have checks and balances on them. And so in the federal system, it created the Supreme Court. And then afterwards, the inferior courts, as we might call them, came into existence. So the Article 3 courts in the federal system are the Supreme Court, the Circuit Courts of Appeal, because there are several different circuits, and the federal district courts.
What does the Supreme Court cover? What's its jurisdiction? What kinds of cases does it hear? Broad brushstrokes.
So broad brushstrokes would be that there are certain cases where it has the first jurisdiction, initial jurisdiction, very few. Controversies between states and certain things like that, and you never hear about those, and they're very rarely invoked. Primarily, it's appeals from the Circuit Court of Appeals. And most of those appeals, if not all, are taken on what's called writ of certiorari, which means that the appellant, the person who's appealing the decision from the Circuit Court of Appeals, is asking the court to take the case, and the Supreme Court doesn't take most of the cases that are appealed by writ of certiorari.
Okay, and then you refer to them as the inferior courts. So the appellate courts, what kinds of cases does the federal level of circuit courts take?
So the circuit courts are hearing appeals from the federal district courts. And so a case, if it's heard in Rhode Island, for example, would be appealed to the circuit court for that jurisdiction, which I believe is the First Circuit Court of Appeals. And that circuit will hear the appeals, and you may have seen this happen where they hear an appeal, and then it's usually a 3-judge panel, and then the appellant who lost or the appellee who lost might ask for a rehearing en banc, meaning before the whole Circuit Court of Appeals, or for reconsideration, and then there right after that would be to appeal to the Supreme Court.
So there's appellate at the state level, there's appellate at the federal level. What are the differences in the kinds of cases that are heard?
Well, that starts with the initial jurisdiction in the federal district court, is what kind of cases can be heard at that level. So any cases that are involving a constitutional question or a federal law are heard at the federal court level initially. It could be a case that even involves state law where there's a federal issue, could be filed there, or a case could be filed based on diversity. And diversity means if the plaintiff and the defendants and all the plaintiffs and all the defendants are from different states, then if the case in controversy is over the threshold amount, which at one time I believe was $50,000, maybe $100,000 now, the district court can take jurisdiction over that case. And a case that is initially filed in a state court that has federal issues might be removed from the state court to the federal court by one of the parties.
Interesting. And in some of my research, I saw that there are 94 district courts at the federal level. That's more than there are states. So is that based on the size? So, for example, California or New York or Boston, or I don't know, whatever. Is it based on the geography and the size of it?
A bigger state may have several district courts. It might be the district court for the Eastern District of New York or the Western District of New York or whatever district in the state that they designate it as. But every large state, not every large state, but states that are large enough may have several district courts, whereas Rhode Island has one federal district court.
And I understand there are 13 district courts, so does Rhode Island share one with our neighbor?
13 circuit courts of appeal.
Circuit courts,
yes,
excuse
so
me.
Those are shared.
Yes, and they're shared.
Right.
And how did those become divvied up? Was it by geography also, I assume?
Yes, pretty
and size?
much. Although, interestingly enough, I believe that the circuit court for Rhode Island is also the circuit court for Puerto Rico.
Now that's an interesting, that'll make a great Trivial Pursuit question someday. So, okay, let's explore the state court system a little bit. Explain how that's broken up. I know there's a thing called general jurisdiction. That's quite a net.
Yep.
Explain what the state system is like.
So in Rhode Island, for example,
as opposed to Mass.
The general jurisdiction many times might be considered the superior court, as long as the case that's being brought is worth or valued enough. So there's a minimum, and then there's a part where the district court in Rhode Island might have concurrent jurisdiction over a civil case. So what happens with civil cases is if it's valued at more than $10,000, you bring that case in the superior court and you plead in your complaint that the jurisdictional amount in controversy is enough to invoke the jurisdiction of the superior court. If it's between 5 and 10, you get to choose, and if it's less than 5,000, you bring that in district court, which many times, if it's below 2,500, might be brought in small claims court within district court.
And what about our state Supreme Court?
So a case that is appealed from superior court can generally be appealed to the Supreme Court. Some cases can be appealed by right, others by writ of certiorari, just like on the federal system. Workers' Compensation Court in Rhode Island, which handles claims of people who got hurt at work, their cases are appealed to the Supreme Court by writ of certiorari. District court cases generally are, for the most part, with some exceptions, appealed to the Superior Court, and many times for what's called a trial de novo or a brand new trial. What happened at the district court level set aside, and the justice in the Superior Court will hear it new.
So at the federal level, there's a lot of discussion about our Constitution. That would mean U.S. Constitution. Each state has its own Constitution as well. Who hears issues about the state Constitution and challenges it or whatever?
Generally speaking, an issue about a state constitution is heard by the state. So if there is a case that's brought, and sometimes a case can be brought and someone wants to challenge the constitutionality of a statute, and sometimes that can be both on federal and state level, but if they're challenging it on the state level, they have to bring the Attorney General into the case so he can defend the statute in question. And then appeal to that would be to the Rhode Island Supreme Court. And sometimes if there's an overlap, it can then be, you can ask to bring it from the Rhode Island Supreme Court to the U.S. Supreme Court on some occasions where a federal constitutional issue is invoked.
Interesting. Okay. The state of Rhode Island has other mini courts. If you were talking about inferior courts before, care to go through the litany of other courts that we have
in the state
in our
level?
state?
Some of our other courts, they're none. I'm not going to call them mini. I'm just going to call them other.
Other, okay.
So there is workers' compensation, which I already mentioned. Family court, which was established out of the Superior Court. Superior Court initially, when there was no family court, this is the 60s, those cases that involved families were heard in the Superior Court on a juvenile calendar sometimes, or other calendars within the Superior Court. And sometime in the 60s, the legislature decided that, you know what, this is a specialty area, we should roll it out of Superior Court and create its own court. And that's how the family court was established. There are also municipal courts and probate courts, which are, by the definition, municipal. It's each city and town can ask the legislature to create a municipal court and give it jurisdiction. Many cities and towns have done that. And every city and town has a probate court.
And then there's that thing that they call the traffic tribunal.
Yeah.
That's its own. Let me ask, is the reason that they made a special court for traffic because there were so many violations, they just needed to handle it that way?
Yes, and at one time I think it was called the Rhode Island Adjudication Division, and they were staffed with magistrates and judges, and now it's the Rhode Island Traffic Tribunal, which is staffed by magistrates.
And just for a point of reference, as I was preparing for this, Massachusetts, they have a different structure. They have a Supreme Judicial Court as their highest court. They have an appeals court as the intermediate appellate court. And then they have 7 trial court departments that, just similar to or analogous to ours, they have a district court, they have muni court, they have a land court, they have a housing court, a juvenile court, a probate and family court, and a superior court. So there are things that are in parallel or certainly similar. And interestingly, they have a structure that I think kind of must parallel ours. I don't imagine that. Who would have come first? Who would have developed theirs first? Or do they do it concurrently? They must have done it.
Yeah. And so Rhode Island has housing courts in some cities and towns too. Otherwise, the housing matters are generally heard in the municipal court.
Okay. And if they were appealed, they would then go to?
So it depends on which case and what type of case is appealed. A traffic case heard in a municipal court is appealed to the traffic tribunal.
Okay.
And the traffic tribunal has a hearing board that will hear, 3 magistrates from the court will hear the appeal on the record to determine whether or not the judge made a mistake. In both traffic tribunal cases and municipal court cases are appealed to that board.
Where do people need lawyers? Do you need a lawyer to go to traffic tribunal? Do you need one to go to family court? Probably. Where don't you need a lawyer these days?
Yeah, probably a better question. Where don't you need a lawyer? So generally, if you have a good driving record and you have to go to the traffic tribunal or a municipal court, you probably don't need a lawyer for that. If you have a bad driving record and you got to go to the traffic tribunal, and you might face what's called the Colin Foot law, where you've had, I think it's 3 or 4 or more citations in an 18-month period, or this is the 4th one, that you might have a suspension or driver's retraining or a hefty fine. You might want to have a lawyer for that.
Of course, DUI cases, certainly.
Absolutely. Refusal.
What about small claims court?
Small claims court generally, if you're not a corporation going to small claims court, but an individual, you could go and represent yourself. It's sort of set up for you to be able to do that.
And if you are in a small but incorporated or LLC business, then what?
Then you have to have a lawyer, because as an individual, you can't represent the entity, and a business is an entity, a separate entity, so that requires representation by a lawyer.
And which court will you be going to for small business?
Small claims.
There's yet another court that we missed?
Well, there's a business calendar in Superior Court, but a small claims court is in the district court.
Okay, in the district court. Okay. So how do people get to sit on the bench? That has always been a contentious issue. I understand, and we will talk about it, but especially in election years. But let's go through the options of how someone ends up being selected or appointed or elected on the bench. How does that happen, say, with the federal court system?
Okay. So we talked about Article 3 courts in the federal system.
Yes.
They're what I might call Article 1 courts, or legislatively created courts, which are ALJs generally. So there's judges appointed to hear cases in certain agencies, such as Social Security. So if you have a Social Security disability claim and you file for Social Security disability and it's denied at one level, then you get to go to another level and then in front of an ALJ or an administrative law judge. And so those are appointed in a different way than Article 3 judges. But just to go through some of those other those areas, as we may have learned, there's immigration judges who are also appointed by actually the Attorney General, because it's part of the Department of Justice. And so there's judges in immigration. There's all sorts of other claim courts and other SEC hearing offices and all sorts of offices in the agencies, which are appointed in a different method. So to answer your question, Article 3 judges are appointed by the President with the advice and consent of the Senate.
The Senate. And it goes through its procedure.
Right.
Which is, I guess, another topic for another
Yes.
day. They hold their office till eternity or until
Lifetime.
challenged?
So in the federal Article 3 courts, it's a lifetime appointment. The other judges, ALJs and Social Security, in other words, have a term. And bankruptcy judges are actually even done a little bit differently. In fact, Rhode Island just had a bankruptcy judge approved, which are picked by the U.S. Circuit Court of Appeals for our jurisdiction.
That's interesting.
Yeah.
Okay.
And one more, in Rhode
Go ahead.
Island, district court judges, federal district court judges, pick magistrates to help with their caseload.
And what is a magistrate?
So a magistrate judge in the U.S. district court system helps with picking juries and hearing motions and doing other things, helping the judge in that district handle their caseload. And again, that's a 10-year term appointed by the majority of the U.S. district court judges.
And that is a person who has a law degree?
Yeah.
Must have a
Yes.
law degree?
Yeah.
Okay. And then at the state court level, those judges are selected in a variety of ways, I guess even by state. Care to go through that, please?
So in Rhode Island, for an appointment to family court, district court, superior court, Supreme Court, and Superior Court, if I missed that one, but all the Rhode Island jurisdictions, there is a judicial nominating committee. If you want to apply, you apply to that. There's a board that hears or commission that hears your application and decides whether to give you an interview, or looks at your application, decides whether to give you an interview. And then those people who are chosen for an interview are then voted upon, and they'll send 3 to 5 names of qualified applicants to the governor to choose from, and then the governor picks with the advice and consent of the Senate.
So what you've sort of described is what they refer to as the combination. In some places, there is just the appointment for a number of years. Sometimes there is an election. We should go through that. And then there are times when there's a combination, what you seem to be describing. If you have a committee, a hearing, a decision, a slate that's presented to the governor, that sounds like it's certainly a more lengthy process. So what would an election look like?
Yeah, so in Rhode Island, just to go back to that for 1 second, when the judge is picked and confirmed by the Senate, picked by the governor and confirmed by the Senate, that's a lifetime appointment as well. The election of judges is for a term. Every system has issues. That one, I think, is fraught with trouble because a judge needs to be independent. And a judge needs to make difficult decisions at certain times in their career. And they can be unpopular, but correct. And you always want to follow the law and apply the law the way it's supposed to be, regardless of political pressure or any other type of outcome, as long as you're doing it in an independent, well thought out manner. Judges who are elected and make an unpopular decision are subject to being unelected. in the next election cycle. And so they may not make the right decision, they may want to make the popular decision. And then you have the issue of political contributions and campaigns and needing to raise money for campaigns. And I think that's an issue, especially if it's in a jurisdiction that allows attorneys to contribute to your campaign. How do you separate out your independence from a political contribution if they're allowed to make those?
What you're saying, you're laying out the complexities very well, obviously, and it seems that there should be some set of guidelines that keeps that from being so contentious, such a problem. I mean, I've heard of partisan elections, nonpartisan elections, but in either case, whether it's people and candidates that are with affiliation or without a political affiliation, but they're still their ideologies, and if there are questions about that, they could be either left-leaning, right-leaning, and still within the law. Same thing with when a president selects somebody to be on the bench, they have to stick with the law, but they have their own ideological leanings. How is that offset?
Yeah, so with elections, it's a little bit different because if you recall, I think it was the Wisconsin Supreme Court election.
I know where you're going.
There were people just weighing in with contributions to both sides, and they had their ideologies put out there and with their political leanings and so forth. And it's just not, to me, the way a court system should run. It should be you're appointed. And so if you're appointed by a governor or a president that is looking for your ideology and your leanings, that's fine to some degree. But you would hope when you're appointed that you call the balls and strikes, as they say, based on the law and not anything else. And so for the most part at the trial level, your political ideology, your leanings left or right, don't usually come into play at all unless we start having to define the constitutionality of a law or something, which is really the Supreme Court's job.
Yes.
You're just supposed to apply the law as it is and based on the precedent that you see. And that's really shouldn't be affected by your political leanings. And when you're appointed to the Supreme Court, it may affect you one way or another as how you might interpret a statute, but your interpretation of the statute should be based on your understanding of the law and not any other outside pressures.
Well, of course, how people choose to interpret, how people interpret even our U.S. Constitution has had a significant impact. It certainly has caused part of the clashes. Right now, we're dealing with however many cases that our Supreme Court has to hear because of our current Trump administration, who has its own feelings about its executive orders, its executive powers, and it's clashing with the judicial system. Depending on how someone is interpreting that, the Supreme Court judges are put in a place of, well, yes, they have to stick with law, David, but it's also some interpretation, and I guess that's part of the challenge, is it not?
Well, it is, and it's certainly appropriate and fine to have different views of how the Constitution should be interpreted, as long as you're following the precedent and the way you're supposed to operate. And I go back to two justices of the Supreme Court who aren't with us any longer. Totally opposite sides of how they saw the appropriate interpretation of the Constitution. Yet they were friends, they respected each other, and they listened to each other, even if they didn't agree with each other. And you know who I'm going to say.
Yes.
Ruth Bader Ginsburg and Antonin Scalia.
Yes.
And they certainly looked at the Constitution differently, but they had a very sound reason for their interpretation of it.
Yes.
And they, I think, would listen to each other in a conference. So what happens after a case is heard, the judges conference, and they go back and forth. I don't think they agreed too often, but I think they listened to why each had their own opinions.
So the Supreme Court justices, they're there for life. we're talking about how some are appointed, some are elected, and you favor the appointment. Is there not, I think I've read this, that there is a time that after they're appointed for a certain term, that then they could be subjected to an election so people can vote on their, well, then it does get to be partisan, I guess, but they get to at least take a look at whether or not they deserve to be retained on that court. Does that offset the political appointments that might be prejudicial? I don't know. How do you feel about it?
I don't think there's a hybrid system where you get appointed and then reelected.
So it says there are some states, but it was at the local level, not certainly higher up, but then they can modify some of these, and they said that there is an assisted appointment method. It comes with a variety of forms, and they can sometimes do that. I can't tell you I can cite a case.
I think what you're referring to is you're appointed, and there may be a review board.
That's what it's a review, yes.
Yeah,
and
the board gets to look to make sure you're doing the job correctly. I'm not familiar with what states have that, but I've heard of that. And there's also another thing, that even if you're appointed for life,
yes,
if you are doing things that are totally inappropriate, you can be in the federal level impeached. And on the state level, there is a judicial disciplinary board that has the power to remove a judge.
If a judge accepts gifts, too many yachts?
There's certainly a lot of different things. There have been cases where a judge was taking loans from attorneys and I believe gambling, and the disciplinary board had the power to remove that judge if he didn't resign. So
I think it makes sense that there is some guidelines. I know right now, between what we hear and read in the headlines every day with the challenge between the Supreme Court and our current presidential level of orders, executive orders, they get to determine whether or not he is guilty of overreaching or even of slowing him down. Does that help? Does that, in your estimation, serve as a balancing act?
It's part of the checks and balances. And there was a Supreme Court decision at the very beginning of our nation, the birth of our nation under the Constitution, where they talked about the judicial review and the authority of the Supreme Court to review things that are done by Congress, constitutionality of laws,
yes,
and the president using executive powers sort of as a replacement to going through the legislative process. And those powers, executive orders, have effect on agencies. They're not laws, they're not passed by Congress, but just like the Supreme Court has the right for judicial review of legislative created laws, they can review executive orders to make sure they pass constitutional muster.
Good, and thank you. Quickly, does it not make sense that I don't know if I want to say conflict, but the tension that's caused is actually a good thing when you talk about checks and balances? If there's that ongoing tension, is that in and of itself probably a positive thing, would you say?
As long as all the different branches of government respect the authority of the other branch of government to do its job. So it is a good thing.
Sounds like a good note on which to conclude. We thank you for tuning in to The Law Matters on this discussion of courts and the judicial system. Please do continue to stay tuned. The law matters to you. Thank you.